So without further ado, I'd like to introduce to you my very dear friend and personal attorney who has helped many of our friends here in San Miguel navigate the wonders of Mexican law. And this is Mariana Salas. She's one of the attorneys at the Prolegal group. This is a group made up of women attorneys, may I add. She's a graduate of the Universidad of Guanajuato with a specialty in public notary. She is a proud San Miguelense, and we are proud to call her a friend of the community. She's here today, to help us navigate, which is pretty much a new world to most of us, the world of wills. I myself, being part of Patronato Pro Niños, deal with wills quite often, as many times we are named in a will, and it can get quite complicated. So being that September is Wills Month, I think it's very important for those of us that own property here that we fully understand how we can protect ourselves and make it easier for loved ones that have to deal with this once we are gone. So I hope that you receive this information in the spirit in which it is intended. We are going to also share a link with you that can help you retain this information. And at the end, we'll also give you some contact information for the Pro Legal Group. So without further ado, I leave you with Mariana Salas. And Mariana, you can take yourself off of mute right now. Thank you so much.
Okay, good morning. Can you hear me there?
We can hear you. Good morning.
Okay, good. Good morning. Is the sound good?
Sound is perfect.
Okay, I just wanted to make sure that you can hear me well. Well, first of all, thank you very much for the opportunity of speaking this morning. It is very important for me to convey what I consider important to protect your estate. As a community, I think it's our obligation as attorneys or as any other profession you may have to share information that may help others. So especially when it comes to something as important as your estate, you must have the best information possible in your hands in order to make better decisions when it comes to your estate. So so I have previously shared with Nori and the Rotary Club a PDF format that you are going to be able to have. And I would much rather not to have something on the screen while I talk, so this is more fluid. So if you agree with that, I'm going to basically start now, okay? Nori, can I just go ahead?
Yes, please, please. We are all ears.
Okay, good. Before I start, I just want to make sure that we're on the same page. I know none of you woke up this morning wanting to go into a classroom to take a law class, but rather something more pragmatic, something that is going to be useful in order for you to make a better decision. So today I'm going to speak about the elements of a last will and testament, the subjects of a last will and testament, and how this document is enforced in Mexico. I will also go through information that I consider relevant and that comes over and over again when it comes to granting a last will and testament, or either when we have to enforce that last will and testament when the person that granted passed away. Okay, so I will go through the elements to start with. So something, this is more theoretical, but I just wanted to make sure to make this point. the last will and testament can be granted in different ways. But in Mexico, the most common last will and testament is the one that is granted before a notary public. We call it a open public last will and testament. Even when it has this name, it's not open, nor is public, okay? Because no one can access your last will and testament until you die. And when the moment comes, besides the person that holds a copy of your last will and testament, only the notary public or the judge can release that information. The last will and testament is considered in terms of law a personal document, meaning that this is a document that you have granted in a confidential manner if you want to see it like that. And the notary public has the obligation to register your last will and testament within the following 3 days you granted your last will and testament. Your last will and testament in Mexico goes to a national database. And when you die, then the notary that takes care of the proceedings or the judge then is able to request a copy of the actual last will and testament you granted. And if you have granted various last wills and testament, don't worry, because the last one will appear in the database. So, because this is the most common last will and testament, and actually the most effective one, I will only talk about that one. Very briefly, I'll let you know that the other types of last will and testaments are a document that you may grant and just deposit in the public registry office, or a document or a last will and testament that is granted in case of emergencies if you are traveling abroad, but that only applies for Mexicans. So I will not stop on those, okay? So I already said this is a very personal act. Then we have specific rules to grant a last will and testament. To start with, the last will and testament has to be granted before a notary public to be completely valid. You may choose the notary public you want to work with, of course. The notary public has the obligation to always take care of this act. So if you're in good health, that's the best option always. However, if you are not in good health, if you have to stay at home, if you're unable to go to the notary public, a notary public cannot refuse to go to your home or assist you in a case of an emergency. The notary public has this specific obligation in the law for notary publics to help someone, to assist a person in case of an emergency, to grant his or her power of attorney. So in the best case scenario, yourself appear before a notary public, then you have to handwrite your last will and testament. This is mandatory. You may add 2 witnesses, but this is optional. My suggestion is, if you have various assets and there may be a controversy among your heirs in the future, then take the witnesses with you. But if you don't foresee any controversy, then just handwrite your last will and testament. Handwriting the last will and testament is only an obligation for non-native speakers. Because what the notary public does is you grant your last will and testament by writing. The notary is assisted by a translator that has to literally translate your last will and testament to the notary. And the notary has the obligation to attach your handwritten last will and testament to the actual document or official stationery the notary has and stamp it. So for a lot of people, it's always very, well, not very hard, but you know what requires to handwrite your last will and testament, but it's a requirement. At this point, it's very important to say that once you have granted the last will and testament, we don't have in Mexico amendments. You just have to redo it if you want to do a modification. So this is why it's also very important to take into account each and every single element, each and every single situation, so you don't have to modify it over and over again because it will cost you every time. A question that I receive constantly is, if I don't have a real estate in Mexico, should I grant the power of attorney? Should I grant a last will and testament? Well, that is up to you really, but for purposes of organizing your estate appropriately, being an attorney, of course, I will always suggest you to grant a last will and testament, even when you only have contents and furniture. You may also have bank accounts in Mexico or any other benefit, insurances, interests in a business, equity, and that could be also included in your last will and testament. It's not only about real estate, but also if you have already decided what you will do with your contents and you have talked to your family or friends, and then you don't need any document in order for them to take those contents out of your property. But preferably, of course, you will be covered with a last will and testament. So what should be included in your last will and testament, talking specifically about assets, real estate property, contents, personal objects. You may also include art, any other, as I said before, any other interest or benefit that you may have in Mexico, such as bank accounts. You can even include the dispositions of how you would like your funeral arrangements to take place. A lot of people include the obligation to the heirs of giving certain amount of money to an organization, a person. Regularly, maids are the most common people that gets a benefit through this last wills and testament. And also, I want to, talking about that, I would like at this moment to make an important point here. When you include in your last will and testament different benefits for several people, let's say a last will and testament where you are leaving your primary home to your children, but you want to give $10,000 to each of your grandchildren, $5,000 to your employees, $2,000 to your nieces. You have to be very careful when you include all of these benefits in your last will and testament, because if it's included in your last will and testament, that means that each and every single beneficiary has to appear before a notary public. So here we may have an issue. Either that person may not be able to come down to Mexico, or may be too expensive to go through the process in order to receive $5,000, $2,000. So my suggestion would be for you to instruct your heirs separately, or your executor or your executrix, to give certain amount of money or these specific goods or assets to these people, so you don't have all these people to either attend or grant a power of attorney. We recently just had this situation with a client of us, and we haven't been able to even start probate because some nieces are in London, and then right there is more expensive to go through the process in exchange of what they would receive. But know that you can always instruct your heirs, even by means of the last will and testament. But instead of saying, this benefit should go to this person, you have to specify your instruction in the last will and testament. I instruct my heirs to give to each of my grandchildren $5,000. That's totally different than saying this person will receive out of my estate $5,000. The instruction to heirs or executors is very different than appointing an heir that will have to appear before a notary public. I will go through the requirements of what an heir has to fulfill, but I want to go through the elements of the last will and testament. So I already told you it has to be handwritten, what you can include, and my recommendation of what you should also include. So now, talking about heirs, when you are appointing an heir, as you may know at this point, in Mexico, we're very peculiar with names. So be sure the names of your heirs are as in their passports. If that specific heir has used different names as a maiden name, better to include the 2 or the 3 names that this person has used over the time. Again, because that person will have to either come down or grant the power of attorney and identify herself or himself, and the name in your last will and testament has to match with the person who's identifying before the notary public or before the judge. You have to establish the proportion each heir should receive. You may also say equal shares. However, you have to prevent, what if one of my heirs is not able to receive the inheritance? What happens to that proportion? If you don't establish what will happen with that proportion in terms of law, what is in the limbo will be divided among your spouse and your children in equal shares. If you don't have spouse or children, then the law establishes that your inheritance will go to the University of Guanajuato to support students. So that process is not very common, but has happened. And here in San Miguel, we have several examples of property that was left without a last will and testament, and University of Guanajuato ended up being the beneficiary. So my recommendation in this case is for you to include in your last will and testament the name of your heirs, the proportion they will receive, and what will happen if one of your heirs is not able or doesn't want to receive that proportion of the inheritance. So you can either decide that that proportion will go to the other heirs in equal shares or will go to other people. Sorry for saying it like this, but when I tell clients that proportion may go to the spouse of the children, they always want to avoid that. So when they know that that's a fact, they always, oh my God, okay, so I'd rather to leave it to my grandchildren or to my other children. And it's totally understandable. I mean, you should do with your inheritance whatever you want, but this is what happens when you don't establish to whom it will be designated in the event someone cannot receive it. It will go directly to that person's spouse and children in equal shares. Mm-hmm. Or if they don't have any children, the other relatives may claim the inheritance, and if there are no other relatives, goes to the University of Guanajuato, as I have said. So I will talk about, at this point, I just want to talk more about the heir's conditions. So when you appoint an heir, regularly you are only thinking about the benefit that represents to this person receiving your inheritance. But there are two sides here. One, and first of all, before going into the taxes drama, I want to talk about the availability of this person to receive the inheritance. So you may appoint an heir that is not in the conditions to come down here to Mexico, nor to grant a power of attorney, because this heir may be living in an area where it's very difficult to access the Mexican consulate, or it's difficult to send the power of attorney to have it notarized and then legalized, or simply this person has a job or a condition that would not allow him or her to come down here. So when you are in this situation, what I recommend is to appoint the heir that is in the condition to come down to Mexico and take care of your estate. And that heir can always be instructed to do with your inheritance what you actually want. I'm going back to the point of appointing several heirs for that sometimes may represent an inconvenience. So if there is full trust in your beneficiaries, it would be good for you to appoint the most suitable heir, let's call it like that, that will take care of the rest. However, if all of them are able to grant a power of attorney from the US or are able to come down here to Mexico to be present and take care of the proceedings, then you don't have any problem. But always think about this. Is my heir able to come down to Mexico? Is my heir able to go and grant a power of attorney? Or is worth it for my heir to go through a process in order to receive a piece of art that may not be as expensive as the expenses your heir is going to be? So I think you have to think about the conditions of the heir before going ahead and appointing this specific heir. Talking about availability, this is very important. In Mexico, inheritances are not taxable. However, the Mexican IRS has established a set of rules for non-residents. And here I just want to be very clear about non-residents, because a lot of people think that we're talking about Mexicans and not Mexicans. No, we're talking about non-residents. You may be a Mexican, but a non-resident in Mexico. So we have a specific chapter in the Mexican law, the income tax law, that establishes that non-residents should pay 25% of the income they are receiving as a consequence of a gift, an inheritance, or any other interest, equity, or whatever they receive when they are not residents in our country. The law also establishes that if the benefit goes from spouse to spouse or from parents to children, not vice versa, children to parents doesn't apply, there should not be that 25%. But I totally ignore why notaries have applied this rule to each and every single circumstance, meaning the 25% tax. Even when the law is very clear about who should pay and who shouldn't, notaries have decided to take the safe route, because notaries are responsible before the Mexican IRS for paying your taxes or the taxes of the beneficiary. So in order to take this safe route, they have decided to charge basically everyone who's not a resident in Mexico with this 25% tax. So what we have been doing in order to avoid this 25% is to become the heir, a resident in our country, whether being a temporal or a permanent resident in the country. So by the only fact that someone is going to receive an estate in Mexico, that should be a sufficient reason for the Mexican consulate abroad to give you the opportunity to become a resident in Mexico. So that person applies abroad, gets the authorization from the Mexican government. Some notaries allow us to start the proceedings just with that authorization. Some others may require for that heir to actually get the card that the Mexican government grants you. And I don't know if they did that, if they actually did this on purpose, but it's a green card. Okay, so and many of you have it, is the resident card granted by immigration. And as some of you may know, it may take right now up to 8 weeks to get it. It's awful, yes, and it's not improving. So to wrap up this, what I want to say is, if you are giving your estate to someone that is not a resident in Mexico, that person will be liable for 25% tax on the value. Fiscal value, don't get scared, it's not commercial value, but it's fiscal value of your estate. The solution is for that person or those people to become residents in our country, but they have to go through the process before the Mexican consulate. So that takes me back to the point where I was telling you to appoint the most suitable heir, because you always may have someone that has more time than others and is able to come down here, stay for the entire 8 weeks to get the card, start the process, and then split the assets among your other beneficiaries as you have instructed. That's the solution. Please take into account that even when you have granted a last will and testament, and you have it like that already, you don't want to change it, that's totally okay. Your heirs can always achieve an agreement if all of them are of age. So what we have done as well is, when we are in a situation like the one I described, when some heirs are not able to come down here for various reasons, then the law allows the heirs of age to make an agreement in regard to the estate. So what we do is that we elaborate an agreement where it's decided that just 2 heirs or 1 heir will receive all the inheritance, and that heir then becomes a resident in Mexico, sells the estate, and splits the funds, or does the distribution of funds, if that is the case. If you are already if you already granted your last will and testament like that, again, it shouldn't be a big concern, because there's always a solution for your heirs to do what you didn't do in that last will and testament. So the next point I have here is the executor and the executrix. Basically the same thing except for taxes. The executor or the executrix may be one of your heirs. In that case, the law establishes, if it's one of my heirs, then there's no obligation to pay your executrix or your executor, because that executor or executrix will already receive a benefit. But if you appoint an executrix or an executor that is not an heir, the law establishes that that person is entitled to receive 2% of the total value of your estate, either a compensation you have appointed in advance in your last will and testament. So most of people establishes a compensation when the executor is an external executrix or executor. The obligations of the executor and the executrix are the same as a power of attorney. That person represents your estate while your heirs adjudicate for themselves the estate. So in the meantime, let's say you decide to rent your property. Well, you have decided that in advance in your last will and testament, or if your heirs decide to rent the property while the proceedings are completed, the executrix or the executor has the responsibility to manage the funds, to do an inventory of the assets, to keep informed the heirs, and also to appear before the notary public in order to accept this post. The law also establishes when it comes to a non-beneficiary executor, sometimes this executor may put down a bond. It's very rare, however, is established in the law. And I would say that in almost 10 years, I have never seen anyone asking an executor to put down a bond. This is not the topic, but when you die without a last will and testament, and you have to take the proceedings before the court, the bond is mandatory for the executor or the executrix. In the last will and testament, is optional, but better to say, I'm not demanding a bond from my executor or executrix, or my executor will not have the obligation to grant a bond in order to perform. It's better to establish that in your last will and testament, as well as the amount of the compensation. Otherwise, as I have said, this person may claim 2% of the total value of your estate. The executor of the executrix will preferably be someone who is available. Someone that is able to take care of your estate. And with this, I mean doing an inventory, protect your assets, talking to your employees if you have, being able to maintain communication with whomever is involved. What regularly happens is people either appoints one of the heirs, and the heir is not able to come down to Mexico immediately. So again, we're in a limbo where nothing is happening because we don't have an executor that represents your estate. When you are appointing a friend of yours, I would suggest for you to add the compensation in the last will and testament. And if you decide to appoint your home manager, your attorney, your accountant as your executor, same thing, just establish the compensation in the last will and testament to avoid that 2%. And if you have decided to appoint an external person, you may also include the obligation of that person to grant a bond equivalent to the amount they will end up receiving at the end of the proceedings, just for your own protection. We have rarely seen cases where the executor doesn't act as they should, but of course there are many cases out there. And also, I will talk about how to better preserve your last will and testament, but those should be the qualities of your executor or your executrix. Think of your executor or executrix as someone who you want to hire to organize your paperwork. Someone who has that capacity. You may have a friend who's perfectly well organized, well driven. Go to that person and ask if that person can take care of that, because this person is going to manage one of your most valuable things, which is your estate. So better to have someone who's not only reliable, but also really well driven and organized as your executor or executrix, even when you have to pay compensation to that person.
Mariana, I think we're at a perfect moment right now. We've got 10 minutes left on the call, and we have quite a few questions, and I think that they're going to help our audience with some specific needs that they have. So if you don't mind, I'll read the questions for you. So one question is, if you need to modify an existing will, is the fee less than writing the original will?
Regularly, yes. The notary public will take this into account, and of course ourselves. If it's a legal modification, if it's a tiny modification, yes, the cost is less regularly. But in this case, you will have to go to the same notary public that already did your last will and testament in order not to be charged double.
Okay. Another good question is, if your money is in the USA, do you need to make arrangements for that money in your Mexican will when you live in Mexico?
Not necessarily, only if you want. Remember that in your bank accounts, you can always appoint a beneficiary. So this is a very important point. Make sure that whomever is the beneficiary in your will is also the beneficiary in your bank accounts. There is always a dispute here because banks abide by federal law, and whomever has been appointed as the beneficiary will receive your money. And the last will and testament is regulated by civil law. So what I recommend is either be sure to match your last will and testament with the beneficiaries that have been appointed in your bank accounts. And if talking about the money in the US, better just to appoint beneficiaries there and they can go directly and get it there. Because using the Mexican last will and testament for that purposes will only add stress and requirements. If your money is here in Mexico, better not to inform the bank about the death of the person. Appoint your beneficiaries and preferably a co-signer that is able to use your money. Don't inform the bank, take the money away, run away. Because otherwise the bank will hold it and ask you for all sort of documents.
Okay. So can you, in your Mexican will, list assets to a US-based family trust?
Yes, you can. Just remember that every single transaction that goes back and forward from Mexico and the US in both directions will require for each and every single document to be notarized and legalized. So if you leave as a beneficiary a family trust, that trust will be needed in Mexico, notarized, legalized, meaning getting the apostille if it comes from the US, legalized if it comes from Canada or other countries, and it has to be translated into Spanish by an official translator. Mm-hmm.
Thank you so much. What are the requirements if you are giving your money to an NGO, for instance, to an animal shelter?
Just be sure that the name of the NGO is correctly spelled, the same thing. In the event that that NGO disappears, appoint a substitute for that.
I can actually speak to that. Make sure that you have the actual name of the NGO as per their acta, right?
Exactly. As per their acta, that's correct.
That would be the best thing. What is the average fee to draw up a valid will?
Mm-hmm. Including notary fees, we're talking about 7,000 pesos.
Okay. And one question was, is it a possibility to do two sets, one in Spanish and one in English?
Yeah, well, actually, it's done. It's bilingual because the one in English that you have handwritten is attached to your one in Spanish. So it's actually a bilingual document. Some people, if your last will and testament will produce effects in the US for any purposes, not necessarily in order to adjudicate any property or estate, but to inform Social Security or other purposes, I would say just have it apostille in advance. To get it legalized in the state of Guanajuato is very inexpensive. It's more expensive to go to Guanajuato than getting the legalization. The legalization is less than 200 pesos. So that's $10 approximately. So my suggestion would be definitely if your last will and testament will produce some effects in the US, once it's ready and registered, have it legalized. Mm-hmm. And send,
two more questions. Yeah. If a will was done in Mexico prior to becoming a permanent resident and then I become a permanent resident, does the will have to be updated or would that adjust automatically?
That is adjust automatically. Something that is just very, very important, and most of the notaries do this already, is besides making a list of all your assets, at the beginning or at the end, say each and every single asset I may have at the time of my death should follow the same order that has been included in this last will and testament. So in the event you sell your current property and buy another one, you don't have to modify it again. Mm-hmm.
What happens when the notary who filed the will dies and then the person who wrote the will dies as well? Can another attorney take over?
Totally, yes. Once you die, the process, and I will just describe it in 4 quick steps. So once the person dies, the executor and the heirs appear before the notary public. That's the easiest way. I will not even go through the judge because that's the difficult way, but you can also go before the judge. But you go before the notary public with the certificate of death, and it doesn't matter who the notary public is. The notary public then requests information to the national database of last wills and testaments, and the notary public will automatically get that information from the database, the national database. So any notary public can start the process. That's the first step. The same notary public then informs about the death of the person through notices in the official newspaper of the state, and then an inventory is submitted before the notary public, and the last step is appraisals and adjudication of the state.
Wonderful. Well, as you can all see, there's lots of information to be learned from all of this. And most importantly, I think it's very critical to the process to sit down and have a really good and clear conversation with a trusted attorney, someone that you can have clear communication with, and who is well versed in the subject, and who can give you the different scenarios that can occur. So I urge you to take this seriously. Like I said earlier, have myself been involved in a number of situations as executive director at Patronato, where well-intended individuals leave us named in a will, and then it gets complicated beyond words. So I urge you to please leave your legacy in a very well and clear manner, so that you can continue to be celebrated well beyond your years. Thank you, Mariana. It's been a pleasure. And
thank you.
I put your contact information up. Of course, this is going to be recorded thanks to our good friend Ron Lennox. And we thank you for that, Ron, always. And we'll make this available to everyone. There are many more questions, but we are running out of time, so I turn it over to Skip.
Thank you, Nori, and thank you, Mariana. Very, very good presentation. A reminder that September is Will Month, which means you get a discount if you get your wills done in the month of September.